All right, good morning. Good morning. Welcome to Inside Pages on Metro Television. My name is Aldo Moro. It's always a pleasure coming your way. It's a beautiful Saturday morning. And I know this is the show you've been waiting for. I know this is the show that you tune in every Saturday morning from 8 to 10 because of the quality of the conversations that we have here and the depth of the analysis that we make here on the show. And so you've never made a mistake by tuning in to Inside Pages. My name once again is Aldo Moro, and I want to say that Inside Pages this morning is going to be looking at what appears to be a very, very contentious matter. It's been a matter which has become a subject of a public debate, a very heinous and a very massive, massive public debate, and it has to do with the anti-gay bill. So Parliament is done with its work, and the Clerk of Parliament was asked to dispatch, but in law they call it transmit, yeah? So Parliament was the Clerk of Parliament was expected to dispatch the bill to the President for the President to sign or to assent to it. The President then says, well, I'm not even going to receive this bill in much less even sign it off because there are some court actions, currently pending before us. And so based on the advice of my Attorney General, I'm unable to do that. And that statement is actually what has actually angered the Speaker of Parliament. Of course, if you also look at the tone of that letter where it says cease and desist, Speaker of Parliament, the Right Honourable Alban Suman Abagbin has actually had cause to respond to the President in some very, very terse words. Because he thinks of it he thinks of the president's actions as one that would undermine the cooperative governance that this country has been looking for. So we're going to get into the details of this very, very vexed matter. I'll take a short break. When I come back, I'll be introducing my resource persons.
Honorable members, I also bring to your attention the receipt of a process from the courts titled Robson Nelson Eche K. Dafiamapo versus the Speaker of Parliament and the Attorney General, suit number J1/12/2024. which process was served on the 19th, that is yesterday, March 2024, and an injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President until the provisions of the Constitution are satisfied. Honorable members, in the light of this process, the House is unable to continue to consider the nominations of His Excellency the President, to use the language of the Attorney General and Minister for Justice, quote, in the spirit of upholding the rule of law, unquote, until after the determination of the application for interlocutory injunction by the Supreme Court. Honorable members, this is the precedent that is being set by His Excellency the President for all Ghanaians to follow. So any matter that comes before Parliament, any Ghanaian can issue a writ and follow it with an application for injunction. And that is enough to injunct Parliament from proceeding with the consideration of the business in the House.
In the instance case of the Human Sexual Rights and Family Values Bill 2024, President Akufo-Addo has taken a strange and alien position, which is unknown to the Constitution of the Republic of Ghana. Given that Parliament has been injuncted in a matter of the President's nominee for the position of ministers and deputy ministers, it is obvious that this Honorable House is also unable and cannot approve those ministerial nominees His Excellency the President has also presented to Parliament. At this point, the President may have to be innovative, dynamic, and think out of the box by downsizing the size of his government. Let me say that merely piling on numbers by way of appointing ministers and deputy ministers does not signal to the people of Ghana that the President understands the seriousness of the mess that he and his government has created in our country. Ladies and gentlemen, let me also say that this may be a good time for President Akufo-Addo to listen to the feedback about the size of his government. At the very least, the two top political parties, namely the NDC and the MPP, agree to downsize government size the way forward. There is an urgent need to downsize the government in order to save the taxpayers from huge cost of running the government. Already, President Mahama has signaled that in his next government, he will not appoint more than 60 ministers. Interestingly, we are also aware that the Vice President, who was part of a government that appointed 125 ministers, has come around to also promise 50 ministers. So all what we are saying is that, may I ask, ladies and gentlemen from the media, what is the prudent justification for a Minister of State at the Ministry of Finance, which with 2 deputy ministers and a Minister of State? Again, why do we have the same ministers and ministers of local government, 2 deputy ministers and a Minister of State at the Ministry of Local Government? Ladies and gentlemen, I wish to conclude by saying that the Right Honorable Speaker has made an important call, a call for Parliament to unite against the autocratic tendencies of our President and this government. We in the NDC minority is ready to protect the sanctity of the Constitution of the Republic of Ghana. And we stand with the Speaker of Parliament in this. Let the President of Ghana and his government be aware that where this country is going is strange under his watch. And the NDC minority will not countenance it. But I want to urge that it is obvious that His Excellency the President has breached the Constitution, and we will advise ourselves. In the coming days, don't be surprised that we will begin impeachment proceedings against the President.
The issue of constitutionality of certain nominees had been determined by way of they going through the vetting process, a report coming before the House for debate and final decision. So for me, these are 2 unrelated issues. How can the Fiamakpo raise an issue regarding a minister who has been transferred? Let's put it in that state, that a minister in one ministry has been moved to another ministry, and the words used by the Mr. President was that he has relieved them of their portfolio and moving them to another ministry. How does that affect a situation where a nominee has been referred to a appointment committee? Appointment committee has vetted that person, brought a report, and you say that there is an injunction application pending. Therefore, such a situation cannot be considered by Parliament. This is bad faith. This is bad faith. Because you have 2 unrelated issues being conjoined to create a certain political effect. But again, since this is a chamber where we will do public business, we believe that we need to reflect on these issues and sit together as stakeholders in this politics to get things done. We will rest our case, but before, let me also express disappointment at the conduct of the minority. Is it the case that they were aware of what was going to happen? Is it the case that they would always see no evil and say no evil? Is it the case that they are in support of this action to obstruct government business? They should remember that the people of Ghana are watching. We have ministers who are supposed to manage ministries, to conduct public business for the benefit of the people of Ghana. What the minority has done today clearly shows that they are not on the side of democracy. Indeed, they want government business to come to a halt through their conduct, because they were nowhere ready to get us to even engage, Mr. Speaker. They were ready to pack and get to their various cars and go home. Obviously, it is a political journey they are on. They want to explore the situation to their advantage, and we believe that the good people of Ghana at the right time will know that we as MPP in government stand for progress, development, and the betterment of our democracy.
Well, so you had the back and forth between the minority and the majority after the Speaker, Alban Sumana Bagbing, actually delivered that statement to Parliament, expressing his grave reservations about the tone, or let's say the form and substance of the letter which was issued by the executive secretary to the president, Nana Santibedi Etuo, to the clerk of Parliament, where it talks about Parliament actually ceasing and desisting from going ahead to even submit or to transmit the letter to the presidency. And that's what the Honorable Speaker of Parliament was very upset about. And right after that, now the Speaker of Parliament did something which was quite instructive. As soon as he delivered that statement, he then adjourned the House sine die. And that in itself became a matter which the majority was very upset about, because they're saying under normal circumstances, has been the practice, has been the convention. What has happened is that typically there will be some, consultations and so on with the leadership of Parliament before such a decision is taken. So what has happened this time around, when there were actually 4 clear other, agenda or agendum, which they would have wished that the Speaker of Parliament would either supervise or superintend over, but the Speaker of Parliament didn't, and they are very upset about that as well. Now, the man who is in the middle of all of this, and I'm talking about the MP for North, I think it's South Dai, the Honourable Dafia Nelson Dafiawakwa, who is the one of the plaintiff in that interlocutory injunction which has been filed in the court, stopping the Speaker of Parliament from going ahead to vet and approve some nominees by the president. He's been explaining why he did that in his reaction to the letter from the presidency. Let's watch him, and right after that, I'll introduce my resource persons.
So the president will receive the remittal containing the bill and acknowledge in the language that you just said that I hereby acknowledge receipt of the bill number this in respect of this legislation. However, as you may be aware, there are 2 actions pending in the Supreme Court regarding the status of this matter. So in the spirit of upholding the law, may we all abide the outcome. This is how you communicate.
And is that what the constitutional provisions provide?
No, it does not. That is not what the constitutional provision provides. But it's a better way of communicating your grievance. If you appreciate what I'm saying, it's a better way of drawing attention to matters that are sub judice to the issue. Then, because the Constitution didn't provide the procedure when this spring into life, we have recourse to case law. Because these matters, Supreme Court have had cause to pronounce on them.
All in all, one thing that is key, and I need to express it here, that the president by no means will disrespect Parliament. The president will not disregard the function and role that the Parliament or the other arm of government does. And I thought that agreeing or allowing the Supreme Court to also weigh in on this issue was rather showing that, listen, there are three arms. Legislative arm has had their way. On this particular issue, let's also hear what the Supreme Court also has to say, so that all three arms of government will have input in this matter. I think that the president was abiding by the laws of the country, and actually.
Yeah, so that was the discussion that actually ensued in the course of the week when the Honorable Nelson Dafiamakbo and his other colleague from the MPP side were having a go at each other as far as the matter in contention is concerned. Let me, at this juncture, introduce my resource persons who've joined us this morning for what would definitely, be a very interesting conversation, matters that border on the law, and for that matter, constitution or constitutionality. I do have via Zoom, first of all, is a Dr. John Osai-Kwapon, who is a CDD fellow, Ghana. Okay, he hasn't joined the Zoom yet, I'm told. He'll be joining us shortly. But let me just quickly do this. So there are some persons who are here with me in the studio. I'll start with the Member of Parliament for Tamale Central, the Honorable Murtala Mohammed, Ibrahim Murtala Mohammed. Good morning, sir. Thank you very much for joining us on the Inside Page. It's always a pleasure having you, sir. Thank you. And also let me say that I have the Honorable Kingsley Amwakwa Buedu, who is not a Member of Parliament. He's a private legal practitioner and also a member of the NPP's communications team. I want to thank you very much for accepting to join us, sir. Thank you. That's Murtala. Right. And also let me say that I have another private legal practitioner. So he will be the ombudsman, so to speak. That's Mr. John in Debugiri, who is also a private legal practitioner, who's got some very interesting views about this matter, this very contentious matter. Honorable, thank you very much for your time.
Thank you.
Or rather say counsel.
Yes.
Counsel.
Yes, I'm not an honorable yet. You should also call me counsel. I'm not
Yeah,
an honorable yet.
okay, counsel. All right, instead of honorable. Yeah, right. That's right. So this is a matter of law, strictly speaking, and of course, lawmaking. But I'll start with the Honorable Member of Parliament for the Tamale Central Constituency. Okay, so I'm told Dr. John Osai-Kwapon has also joined us via Zoom. Dr. John Osai-Kwapon is a political scientist, also a fellow of CDD Ghana. Thank you very much for joining us. Good morning.
Good morning. My pleasure.
Thank you. Thank you so very much. So I'll start with the politicians before I bring in John Ndebugri and yourself to help make sense and put all of these things in perspective for us. So I'll start with you, Honorable Member of Parliament for the Tamale Central Constituency. So you were very critical of the president when he went ahead to sign off the e-levy when it was passed in Parliament. You chastised the president, you lampooned the president, you're very critical of him because you said it was a matter pending in court. So why did he go ahead to sign it off? Now, interestingly, you have a situation where a bill which you have prepared or you have enacted in Parliament and the constitutional provisions, which is Article 106, you expect the president to sign it off when it is transmitted to him. The president says, well, I can't do that based on the advice of the Attorney General because there's a matter pending in court. And that matter is an interlocutory injunction which has been filed by two citizens of Ghana, Richard Sky and one Dr. Amanda. How then do you now turn around to blame the president for doing something you've always wanted him to do, which is once the matter is in court, stay off? What's the difference?
Well,
where's the consistency?
Good morning, Muru, and good morning to my colleagues, and good morning to your cherished viewers, and most importantly, the good people of Tamale Central. And permit me to wish all Muslims across the country Ramadan Mubarak, because I haven't been here since the fasting began.
Right.
So it is always proper that I wish people. We are getting to the second, in fact, we are in the second half of the 30 or 29 days And these are the times for blessing. And I tell people that the difficulty most of us go through during Ramadan is lack of sleep.
Right.
Yesterday, unfortunately, Nanado visited my area, and I believe many homes. Unfortunately, we're in Dumso. So he visited many homes. And
well, I thought he was there physically.
The tahajjud, I had to perform my tahajjud with the lights of my phone. And that was what I had to do. And I can imagine many people who didn't have phones, they would have been denied the opportunity to do so. Sometimes when I listen to these discussions, and then when you say it's a legal matter, it's about law, I get extremely irritated.
Right.
You don't need to be a lawyer to discuss these matters. And I've always said, you come to Parliament, how many MPs are lawyers?
Right.
Meanwhile, the core function of Parliament is to legislate, to make laws. So let us not do that to exclude those who necessarily are not lawyers. To engage in such discussion. Laws were made or are made based on simple common sense.
Right.
I mean, the common law that we have was the British customary laws, that we have taken it, then it evolved to become a common law, and then we blend it with our customary laws. And every customary laws that are made by people are made to regulate the conduct of people who live in those societies, so that they can live in peace and harmony with some level of decency. So our laws are also the common law, which indeed evolved through the British customary law and our customary law. So certain customary practices we deem unfit to continue, we do that. We exclude them. Mind you, even the British, some of our customs were considered to be barbaric.
Right.
But as far as we are concerned, we consider them to be customs that we need to continue. Polygamous marriage. And I tell people that it is not just a religious thing. It's an African thing.
Right.
It's a thing for humanity.
Right.
In their part of the world, they were engaged also in polygamous marriage some decades or centuries ago, until it got to a time that they decided that no, we want to transit from that particular polygamous marriage to another aspect of marriage, which has occasioned the topic for which reason we are having this discussion, or the issue for which reason we are having it as a topic today to discuss the LGBTQ nonsense. So it is important for us to look at it in that perspective.
Okay.
Let us also be very clear that the president had indicated when he granted interview to Al Jazeera on the matter of the LGBTQ nonsense. And I say LGBTQ nonsense without any apology. I mean, something that is not properly even defined. LGBTQ plus. Nobody knows what that plus is. So it means that at any point in time, anybody who is delusionary or who is deranged can decide that I want to do this, and it ought to be added, all in the name of human rights. Who determines human rights? Human rights are determined by the people in every society. In fact, what is even legally acceptable is determined by a society that is making the law. Lawyers, is that not the case? Because look, after in the Nuremberg trial, when the German Nazis were being prosecuted, do you know the defense of some of them over the Holocaust? They said that as far as they are concerned, what they were doing, the barbarous killing of Jews, was acceptable by the society in which they live. And that was their defense. So laws are not necessarily things that are in sync with rationality. But they are things that are in sync by the people who live in a particular society. Of course, one can argue that we may have international laws. Even the international laws, people have problems with them. So I am saying that the president indeed had made his position very clear when he granted the interview. It took pressure by religious groups, by Ghanaians and by people for him to attend a church program somewhere. I think, I don't know whether it was in Brunei or Eastern region, Mampong, and said that he wouldn't allow LGBTQ, or he will not do anything that will promote LGBTQ in Ghana. But the first statement he made, he said, look, it is bound to happen. And they asked him, how is it going to happen? He said, when there is that movement or a pressure group that begins. So clearly the president was in support of the LGBTQ. So it took pressure of the people of this country for him to take the position he has taken. But let me also state, look, Moro, before we rose, on these same matters of, one, there was this loan they wanted us to approve, about $150 million loan, which we thought was nothing but trying to rob the people of this country the more, and some tax exemption and the approval. The presidency informed Parliament that if we should allow those things to to be taken before we can transmit this to the presidency, because they were scared that they would lose some monies which they would have been they are seeking to get from the IMF. And in fact, we should allow the IMF loan, the loan we are seeking from the IMF, we should allow that loan to be accessed before we can even pass the LGBT, this, proper family values and sexual whatever. This was what the communication we had, unofficial communication.
Okay.
That we shouldn't pass the bill into law until they access this loan from the IMF. And we said no. Ask anybody, if they want to be sincere, they will tell you that this communication was given to us. And we said we won't allow that to happen. No Western country can determine to us how we run the affairs of our country.
Yes.
And this fixation, this fear of thinking that the threat and the weaponization of aid and loans to African countries to accept what is not in sync to our values, our way of life, I think that we must begin to be bold enough to stand up against them. Some countries indeed were bold. Uganda did that. Their economy is thriving. They are doing very well.
Are you saying this is what all of this is about?
It is all about that. It is all about...
It's not a matter of law.
It has nothing to do with law. It has to do with monies the president wants to access from the IMF. Why? The Minister for Finance, and who rather bizarrely, because knowing my senior brother and my teacher, and knowing his position when it comes to Islamic jurisprudence, and knowing his position when it comes to the dean, he said that, look, if government assent to the LGBTQ, we would lose the monies we get from the IMF. This was the Minister for Finance. So this thing has nothing to do with law. It has absolutely nothing to do with law. It has to do with the money. Look, regardless the flip-flopping of the president or the matter of the LGBTQ, I sincerely believe that he is also against the LGBTQ. That's my sincerest position. But the point is that, regardless if he's flip-flopping, but he's always dancing to the tune of the West, because he thinks that if I support the LGBTQ thing, I will lose money. And this is not secret. They have threatened African countries with loans and with aid. And the impression that is created as if we can't survive with those financial assistance. They are not giving us money free.
But the members of parliament...
I said they are not giving us money free.
But Honorable, but the members of parliament who are MPP,
Yeah.
who all belong to the same family, the president and the members of parliament, and they belong to the same family, I'm saying the MPP stock,
Yeah.
have all voted in favor of this bill.
Moro, when we started this
then,
bill... Moro,
in fact,
Moro,
the bill has the input of the Attorney General.
Moro,
So
over
how do you turn around
27
to say-
amendments were effected by the Attorney General. Let me tell you, when we started this, Moro, my name would have been one of the names of the promoters of the bill.
Okay.
When we had these discussions and we started working on it, then I was in Tamale when they were supposed to send it to the Speaker. And Honorable Sam George called, and I said I was in Tamale, whether they could wait the next day, then I come and sign, because all those who were participating in promoting this bill needed to have indeed signed to it. So they could not have waited. So I said they can go ahead. There were other NPP members of parliament, including my good friend, the Deputy Minister for Education, Reverend Mfojo. How come that when they went to them to sign, they all refused to sign? Reverend Mfojo, because he's a Reverend Minister, there was no way he could retreat. And that is why he is the only MPP member whose name is part of the 8 members of parliament who promoted this bill, and a signatory. There were more than 7, 8 MPP members who participated in working through this bill because they had pressure from the presidency. And that was the reason why they all retreated. And I can tell you, some of them expressed misgiving about the pressure that was exerted on them by the Flagstaff House. So it has got nothing to do with law. The law is just used as a smokescreen. But let me tell you,
the majority of the MPs contributed or voted for this bill out of duress?
I'm saying that because, you see, a lot of the MPP members, if you ask me, I can tell you that maybe almost all the MPP members were in support of this bill.
Okay.
Clearly.
Yes.
We had a bipartisan support for the bill.
Right.
But the question is, was the presidency, the government, in support of the bill? No. And I say no because those who refused to sign when the bill was being sent to, the document was being sent to the Speaker, gave reasons why they didn't. But Reverend Mfojo could not have refused to sign because of his stature and his position as a Reverend Minister, and knowing the position of Christianity on the matter.
Okay.
So I am saying that the others who indeed refused to sign, not that they were against what we were doing, but they were scared, and particularly some of them were ministers of states. So that is the point. The presidency, and like I have told you, genuinely maybe if the president would be for the bill. But you see, there is that pressure, and they don't hide this. The Western world do not hide this. They do not hide the threat. They issue. Look,
so that means you sympathize with the president.
Well, I don't sympathize with him.
No, because you're saying.
No, I don't sympathize with him.
Because you're saying that the president would have wished to sign.
No, I don't sympathize.
But for external forces.
No, I don't sympathize with him because he's a coward. Why? Look, when the Nazi Germans were at the brink of invading United Kingdom, after they invaded France, and Halifax advised Churchill that they should surrender to the force that was at the borders of United Kingdom by the Nazi Germans. You know why he said? He said, even if we are lying on the floor of this parliament, talking in our own blood, we shall not surrender.
All right.
It has to do with the values, our way of life. And you see, I started by looking at this common law and others because the common law was a creation of the customary laws of the British.
All right.
And now we have taken it, it has evolved.
Okay.
And every law, when you make them, it evolves. You change certain things,
Right.
you amend certain things, you correct certain things.
around
And now we have taken it as part of our laws. So to conclude,
Yes.
every aspect of our laws must be things that should be in sync
Okay.
with our way of life, our acceptable way of life, and our values.
right.
And that is why I say that, as my preliminary comment, this thing has nothing to do with law.
Okay.
It has to do with the threat that is being exerted by not just our president, but African president by the West, who think that we must accept what they want.
Okay.
And if you refuse to accept that, we won't give you the crumbs. To hell with those crumbs.
All right.
Uganda has done that, and Uganda is thriving. And how come that when they go to the Middle East, Saudi Arabia, Qatar,
Okay.
Kuwait, they don't tell them
All right.
to practice LGBTQ nonsense. When they come to us, they tell us to practice it because we go to them cups in hand, begging to survive when we have the resources to survive independently.
Let me come to Counsel Kingsley or Lawyer Kingsley Mwakwa Boedu. Now, here's the thing. If you listen carefully to what the Honourable Member of Parliament is saying, he's saying that this is not a matter of law and that what the presidency has been attempting to do is to hide under the law, play legal gymnastics because there is a morbid fear in signing of this bill for obvious ramifications. And he mentions one of them, which is being that you don't want the IMF to be angry with you. And so one of the ways in which you've sought to delay this bill into coming to law is to play to the legal gallery. Well, matter is in court, and so on and so forth. And so I can't sign. In fact, I can't even receive it, much less sign of the bill. How do you respond to this, the claim by the Honourable Member of Parliament?
Well, good morning again to our viewers and my fellow panelists. I would want to move away from the position of my very good friend.
If I'm a very good friend, why are you moving away from my position?
No, it's just which is to say he respectfully disagrees.
In part,
Right.
In part, I am glad that Honorable is saying that he doesn't believe the president is in support of that lifestyle.
Right.
I'm very glad because in some quarters they make it look like the president is in support and they will trace it to some family member in the 60s and whatnot. I think we should move away from
I said,
that.
I don't want to believe.
You said yes. That
I don't
you
want
said,
to believe
you said
that he'll be in support
You
of
actually believe that he doesn't support that.
I don't want to believe he would because he's
Great.
a married man who has kids.
Great.
But
Great.
there are people who are married.
The
and
president is straight. So
yes, there are people who are married and they are still doing it. I'm told.
So, and I'm very glad, and I'm very glad.
It's important
that.
to you, extremely.
And I'm also glad that he speaks about our position as a nation.
Okay.
All right, our customs. And there are different customary systems.
Right.
None of them is in support of this.
Right.
Then if you have my brothers did a shout out to the Muslim community.
Right.
I think the Christian community. This is the Lent, and tomorrow is Hosanna in church and all
Okay.
that. And so that one too, there's some fasting going on. And are you fasting?
Please let's not digress. I beg you. Let's go because we don't have all day.
I
By the
think
time we
it's
say
my brother.
Jack, it's almost 10. Please let's go ahead.
You see?
Right.
And so there's nothing about us that respects or would say that we will allow that to happen. And it's a shame that the international community would dwell on Ghana to think that Ghana will cower to that.
Okay.
It will not happen.
Right.
Now, to say that all that is happening is for fear of IMF and all that,
Okay.
I also disagree with that because we are a member. We subscribe to the IMF. We have
Okay.
special drawing rights.
Okay.
Whether the money comes or not is dependent on certain things we do. We pay. That's why we have that special drawing right.
Yeah.
Okay. Of course, when they're coming, they look at the economic conditions and they want to satisfy themselves whether the money that is coming in we will be able to pay over a period of time. That is why they will put conditionalities.
Okay.
They are not saying that part of those conditionalities are your social orientation or your sexual preferences.
Right.
No. They have never said that. It is a World Bank, which is different from IMF. That may talk about that because the World Bank will now look at developmental issues and then make it as if it's a human rights issue and there's some persecution and things like that. So let's distinguish the
So
two.
both the IMF and the World Bank have stated it quite categorically. They believe in inclusivity.
Precisely.
So if there are any laws that seems to be in what I'll call at variance with that, they definitely will have an issue.
Yes, but it doesn't mean that we don't have a special drawing rights from IMF.
That's
for World
true.
Bank, you see,
That's true.
World Bank,
It's not a condition precedent.
exactly.
I agree
And
with
World Bank will give supporting that IMF thing. That's the issue. It's the World Bank that gives some funds and guarantees that supports
Right.
the IMF. That is what
Right.
we have an issue with.
Right.
Now, I am also glad that my brother is saying that other countries have not cut out to them and they are progressing. If it comes to that, and it will come to that, let us accept that we are doing our homegrown policies and our homegrown decisions, and at the moment, there may be some tightening of the belt, and we have to go through that and not politicize that. Because it's a collective decision we are making that we do not support this lifestyle. We do not. And you see, once we say that, freedom comes with responsibility.
Right.
So we will go through that and not politicize it.
Okay.
Now, back to the issue. To say that it's not legal, I disagree with that because you see, no, it is at the moment. It is at the moment because you see, Parliament passed. You said the Attorney General made some recommendations. He said 20-something.
Yes, amendments.
Amendments.
Yes,
And
to the
I
bill.
even advised that they should remove something, some name and all that, which was positive. Remember when the Attorney General was being vetted, he said that we must also have a right to profess that we are against this. If they have a right to say that they are for it, we
Right.
must also have a right to profess that we are against it.
Right.
You see?
Let's now make some progress to why the president has
Wait, so
decided
I'm coming to
okay.
that. So, now, once that bill is passed and is being transmitted to the presidency, and another person issues a writ in a Supreme Court and actually files for an injunction, that will stop it momentarily. It is not final, momentarily. And so if we want to go ahead quickly, all we need to do is get the both parties, and remember, Parliament itself is a party has been sued. Not the presidency, but Parliament.
Right.
All right?
Right.
Which includes the Speaker. All right? And so then, you are supposed to maintain the status quo ante, which is ante is before. So what was the status before this? Keep it there, freeze it.
Okay.
If we want to hurry it up, let both parties go to court. And remember, the Parliament is defended by the Attorney General. If Parliament is sued, it's government. It's the Attorney General that will defend it. If the judiciary is sued, same.
Really?
Attorney General, yes.
Oh, the Attorney
Because-
General is a lawyer for
the
both the
government.
judiciary,
Exactly.
the legislature, and the executive arm of government?
Exactly. He's a lawyer for the government. Government has 3 arms.
Okay.
Okay. So if you look at the proceedings, AG's name is there,
Yes.
isn't it?
Oh, so then that then explains why the Attorney General had to advise
Exactly.
or express
And
an
he has
opinion,
legal opinion.
and of which was
So what
No,
opinion-
all he's saying is
It's not in substance. It's about the procedure, not in
Exactly.
substance, not in terms of the bill
Exactly.
itself.
So-
but it's about the matters of pending before the court.
Precisely.
And
You
what
see,
he thinks of it,
and you
in
see-
terms of whether
and
the
you
president, the
see-
speaker can go ahead or
and you
not.
see,
Yes.
There are some instances where, as a lawyer, you get a process,
Yes.
and in your mind you're just chuckling and say, but this is not going anywhere.
Okay.
But you cannot even voice it.
Yeah.
Why? Because once it's before the court, it's sub judice. You cannot
Right.
comment on the success or otherwise of it.
True.
Otherwise, you've prejudged it.
Right.
You see, so all of us will see it and say, oh. And then, but still, you have to restrain yourself. That is the position
Yes.
of the government.
Okay.
That is the position. That is also to say that even the transmitting of it, all right, is taking an action.
Right.
So don't even transmit it.
Okay.
Oh.
All of us, yes, because Parliament, you are a party. So don't transmit it. The clerk,
I will.
don't
Okay.
transmit it.
Right.
All right. That's all.
Right.
Now, if you want to hurry it up, parties go to court, average time.
Right.
It is always done. Because if you look at the processes, the date is not given. There's no date stated on it. Does it mean that we must also fold our hand and to the hand and wait till wherever the registrar or the Supreme Court decides to to fix a date? No. We can go to court. We can issue a hearing notice, go to court, and make an application to
Right.
average the time.
Right.
Okay, so we can do this. Now, we should be mindful that when we are seeking to respect the authority of the court, the Supreme Court, we shouldn't make it as if those who are saying, let's respect the Supreme Court, are against the bill. All of us are for the bill. It's a very good thing. We have, and then also we have, I, for instance, have issue with some aspect of it. The moment you start commenting on that, it's like, oh, no, that means that you are against the bill. No. The fact is that nobody should have the guts to come to Ghana and dictate to us how we should. There
Kingsley,
should not be cultural imperialism. They cannot have
Kingsley,
it.
the contentious issues here is
Yes.
that the Constitution provides a framework,
Yeah.
and the framework is quite clear,
Yes.
which is Article 106, on how a bill is expected, or how a bill transforms into becoming a law.
Yes.
And it talks about how it goes through the different stages, consideration stage, and so on. And then finally, when it is done, Parliament, through the clerk, then transmits the bill to the president. The president can take a, just like it happened with the witchcraft bill.
Yeah.
President takes a look at the bill, and based on the advice of the Attorney General, which can be either sign or don't sign, and then the reasons are given. Of course, if it signs, no reason, but if it doesn't sign, a reason is given.
Yeah.
And then they sent back to Parliament, and the Parliament to look at it, whether the president's reservations or issues it has raised against the bill are valid or not. Okay, and then Parliament then takes it from there.
Yes.
Or the president can go through the Article 90, which is the Council of State route.
Yes.
Have a look at it, bring it back, and then we'll take it from there. Now, where in the Constitution does it say that the president has the discretion of saying that I cannot even accept the bill in the first place, much less even decide whether to sign or not? So the question which everybody's asking is that where was the president's authority in deciding that it is not going to accept the bill at all until and unless the interlocutory injunction which has been filed in court has been determined. That's the word I was looking for. So where is the authority to back the decision by the president based on advice of the Attorney General? When you read the Attorney General's advice to the president, there's a portion where it says, in light of the foregoing, so I think I have. It says, in light of in the circumstances, I have the view that assenting to the bill, whilst the applications for interlocutory injunction filed in two suits are pending, will render the said applications otiose right, and undermine the authority of the Supreme Court to determine the issues raised in them, in the spirit of upholding the rule of law, as you're obliged to do, I will respectfully advise that a decision to assent the bill be made after the determination of the applications for interlocutory injunction, copies of which are enclosed herein. And it says, accept your excellency assurance of my highest esteem. But
Great.
where in this does it say that don't even accept the bill at all? It says no sign.
Now you're taking me to the classroom. I always don't want to go
No, we
to
want
the
to go.
classroom.
We want to go to the
But I
classroom.
caveat.
Yes,
You
just
see-
briefly, because I want to bring in
there are
John
sources
and
sources
Mother.
of law.
Right.
All right.
Okay.
Constitution, acts, regulations, common law,
And so on.
our customs and all that.
Right.
Article 11. Now, you do not need to have all of that in the Constitution. Now, it is trite law that you cannot take any step that flies in the face of the authority of the courts. All right?
So that's what we call that's established law.
Exactly. Now, even when you look at, you read Article 106, or
Yes.
look at 107, it says, Parliament shall have no power to pass any law, to alter the decision or judgment of any court as between the parties, subject to that decision or judgment, or which operates retrospectively to impose limitations and whatnot. So
Okay.
this is the closest we come to parliamentary action that would negate the effect of the court
Okay.
or the decision of the court.
Okay.
Now, common law principles. Once a matter is before the court, you do not take any action, take any steps
Okay.
that will render it negatory.
Right.
Can I ask
Right.
you a question?
Okay.
Okay, yeah, you can ask.
What would have been negated if the Speaker had gone ahead, the President had gone ahead to accept the bill, the transmission of it,
Yes.
and sent it to it? Would he have been violating any law?
No, I think if you had ended at
No, I'm saying-
accepted, if you had ended at
So would you
accepted,
have-
I
yes.
probably would have given you a
So
different answer.
even if he gives his assent, would he
No,
be violating?
yes,
law?
of course.
How? Which law?
Because you see,
Which
the,
law?
the law is clear that when a court has to determine whether or not the president must give assent to
I said, which law would he be violating because the president
I'm
has...
explaining. I don't need to quote Article so and so.
No,
and so
I'm
and
not
so.
talking. So I'm saying
But,
that.
so I'm explaining it. The position of the law is that when the court is seized with a matter,
Yes.
any action you take that renders it negatory
Right.
is contempt of court.
No, so I'm saying, can I ask this
And
question?
that
So, for
applies-
instance,
that
That
applies-
applies.
Yes.
So does it
For
apply?
instance, wait.
Yeah, no, no,
let me-
no,
I asked the question. I want some
No,
clarity.
yeah,
I'm doing-
honorable.
Does
Please,
it apply?
in order-
Does it apply to the
I am trying to
presidency?
answer you by
Yes,
giving
honorable,
scenarios.
please, yes, so that
For
he can-
instance,
so that he can learn.
two of us are fighting over a plot of
Yeah.
land.
Yes.
All right. You go to court. You don't file an injunction.
Yeah.
One person can build.
Yeah,
But if you go and dispose of that land,
yeah,
now you sold the land.
yeah.
All right. Then it renders whatever decision the court will arrive at negatory. Because the land is not even.
Do you know why I was asking the question?
You see.
Do-
So
do-
in this case, if he signs it into law,
Yeah. It will render what the...
Whatever,
So
yes.
the question
That's
I want to ask,
negatory.
mind you,
Yes.
I know you and you appreciate separation of powers.
exactly.
Good. So, and separation of powers matter in a
Yes,
democracy.
exactly.
In fact, the entire values and principles of democracy is anchored on separation of powers.
So you see
Agree.
that. So you
Can-
see
can I-
that
can I
there
finish?
are legal
Can I
aspects of
finish? No.
everything.
Can I?
You
Can
can't
I?
say that
no,
there's no law.
No, it's
But
not.
when
It's not
you are
necess-
discussing
It's
law.
not necessarily law.
It is law.
No,
What you said is law.
I'm saying it's not necessarily law. Separation
What
of
you
powers.
said
Can I
is law. That's
make a
Montesquieu's
point?
principles.
I'm
That
saying-
governs-
that's not law. It's
that
a principle.
governs-
That's
that-
not law.
that-
It's
no,
a principle.
there is-
The
there
point
is
I'm-
something had their
no,
take, I beg you. I mean, to be fair to them.
I know. I want
Let
him.
me give
I
it to
want
them.
him to answer it. It's important.
No, he's not, he may
No,
not be able to answer because
if I don't raise that,
he's actually exhausted his
Moro,
time. So
but
I'll come back to
let
him
me
briefly.
just conclude on the
You
question.
see,
Maybe.
There are others who are they haven't spoken at all. To be fair to
laws of
them,
law
I can't
that-
keep honorable
No, I
sitting
wanted
there
to
for
ask
a
a
while.
question. You haven't even allowed me to.
No, I
finish.
know what you want to. When you
How do you
ask
mean?
it, when I come back to you and you ask it,
Okay.
or the council respond to it. Let me come to John Ndebogri. Now, John Ndebogri, what's your appreciation of Article 106 relative to the injunction, with the interlocutory injunction which has been filed in court? And for me, more importantly, the whole theory or principle of interlocutory injunction, does that apply to the president, chief of the CJ, Speaker of Parliament, and so on? I'm talking about the heads of the organs of the government or the institutions of state, and our arms of government. Does that apply to all of them? What's your appreciation of the law relative to these issues?
Right. Thank you very much. First of all, I would want to tackle the legislative power of Parliament.
Right.
As contained in Article 106
right.
of the 1992 Constitution.
Right.
Yes, I would not rather want to start from the beginning because I want to start at where the issue arose.
Okay.
Yes, so Parliament has gone ahead to pass a bill.
Right.
And it is the next step which has to go to the executive. And that is where the problem has arisen.
Okay.
Now, if you look at the relevant provision of the Constitution, which is Article 107, Clause, in fact, rather Clause 7 of Article 107.
Okay.
1067.
1067.
Clause 7.
Clause 7.
No, I want to start my argument from 7.
Okay, that's fine.
From
seven.
Clause 7.
Yes. And he's going to tell us why. So
No, I was just only reminding you that you mistakenly said 107.
Oh, okay,
So it's
okay.
106, Clause
106,
7.
yeah, okay.
Okay, 106.
I said Clause 7 of,
Right.
of Article 107. 106, yes. Yes, with your permission, if I may just read it and interpret it here. Clause 7 reads, where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill or that he refuses to assent to the bill, unless the bill has been referred by the President to the Council of State under Article 90 of this Constitution. Now, if you read the Clause 8, so where the President refuses to assent to a bill, he shall, within 14 days after the refusal, first, that's 1A, state in a memorandum to the Speaker any specific reasons, any specific provisions of the bill, which, in his opinion, should be reconsidered by Parliament, including his recommendations for amendments, if any, or B, inform the Speaker that he has referred the bill to the Council of State for consideration and comment under Article 90 of the Constitution. Now, the meaning that can be assigned to these two clauses of Article 106 is that, first of all, when the bill is transmitted to the President has the power by the Constitution to accept it. But accepting it does not automatically mean that when you accept the bill, he should assent to it.
Right.
Yes, you can accept the bill, and give reasons why. In fact, the law says that within 7 days, communicate back to the Speaker that I will assent to the bill or I will not assent to the bill.
Right.
And it goes ahead to say if you will not assent to the bill, the President is bound. Is bound to give only 2 reasons. That's Clause 8. 2 reasons. First of all, the President must state with specificity any defect in the bill, which he thinks that Parliament should reconsider it. Or the second leg of it is that the President can tell Parliament that yes, I've received it, I'm not assenting to it because I've referred it to the Council of State in terms of Article 90 of the Constitution.
Okay.
In my view, these are the only 2 circumstances that can put fetters. In fact, those are the only 2 justifiable reasons that the President can give for refusing to assent to the bill.
The bill.
Now, listening to the portion you read on the opinion proffered by the Attorney General to the President.
Yes.
The Attorney General said that the President should not assent.
Yes.
The Attorney General didn't say that the President should not receive.
Right.
So the President had the power to receive the bill, except that the President more or less put fetters on his own way. We had constitutional backing to accept it. Yes. Now, I've listened and I've heard some legal opinions expressed that an application for injunction, once served, automatically operates as an injunction. Yes. Yes, it's tried learning, yes.
Okay.
But mind you, we are dealing with the Constitution here. Injunctions are equitable relief, as my brother rightly said, is from the common law origin.
Yes.
And it's tried learning, even where a Supreme Court decision conflicts with a provision of the Constitution, that Supreme Court decision must give way.
Okay.
Yes, where even a Supreme Court decision, no matter how exalted, in fact, a court decision, no matter how exalted it is, even in conflict with even an act of parliament, let alone the constitution, obeisance must be due to statute. And my learned friend would agree with me that.
So help me understand this. For mere mortals like us who do not appreciate the law, you're saying that if there's any established law which has been stated by, say, a judge, or say by an act, or by the other, what you're telling us is that once it is at variance with what the Constitution, the 1992 Constitution, expects of us,
it must give way.
It declares it null and void.
It must give way in terms of this. No, I'm saying
it must
that,
give way.
Yes.
No. I think what you're saying is partly right. But if it is at variance with a statute,
yes,
the Supreme Court will not even give that ruling or judgment.
Okay.
Because the Supreme Court, unless it is interpreting that act to say it is unconstitutional, the Supreme Court will not even interfere with the work.
Moro, you see the point I was making. That's why I wanted to make that point.
Yeah, no, that's fine.
They will not even interfere because they are bound by an act.
Okay,
the
no
Supreme
problem.
Court is bound by an
No, I
act.
think we should. You know what? In order that he doesn't, in order that you don't distort his flow of thought. Let him, when it's done, we put which man note. As soon as it's done, you can come in with your rebuttal.
The point that I'm making is that yes, it is tried learning.
His opinion is expressing.
Yes, it is tried learning that once you have been served with an injunction application,
yes,
it means that stopped, even though the injunction has not been moved.
Okay.
Yes, you are not supposed to take any step.
Okay.
Yes.
Right.
And I'm saying that in this case, we are dealing with the national constitution,
right,
which my learned friend knows that interpreting is completely different from interpreting rules of procedure or rules of court.
Right.
Or interpreting even a common law position.
Okay.
Now, the Constitution says black and white what the president can do in Article 106, clauses 7 and 8.
Okay.
It is clearly stated in the Constitution. And I'm saying that even if there's a conflict between these provisions and that of the effect of an injunction, and even there has been a Supreme Court or a Superior Court pronouncement on it, be it a High Court, a Court of Appeal, or the Supreme Court, it is tried learning that obeisance must be due to statute. And this one is even superior to statute.
Yes.
Even if it were an ordinary act of parliament, obeisance must be, but this one is even superior to an act of parliament. So I'm saying that. But beyond that, even if the president wanted to even say that because of the injunction application, I'm unable to proceed, that at least the president could have even accepted it and said, okay, well, to every rule there's an exception, because the Constitution, it is said, is a dynamic living organism that is capable of growth and development.
So, based on your understanding of Article 106, he must accept it.
Yes.
And then state the grounds upon which he's unable to take any action.
And even those grounds are only two as provided by the Constitution. And if the president wanted to even add a third one, well, there's always a but in law. Because at the time of the draft of the Constitution, maybe the drafters or the could not have foreseen what we are encountering today.
Right.
So the president considered, in view of maybe the pending application, I've received it, but I'm unable to act on it. And this would not have been contempt of any court. Well, he has not taken any step. I've received it, I'm not acting on it.
Well, again, advise me on something, educate me on something. Can the president be sued in his capacity as president? I mean, whilst being president. So, for instance, can the president be charged for contempt? And I'm asking this because the people who are saying what the president did was right, was that if the president went ahead, of course, based on the advice of the Attorney General, if the president went ahead to sign it would have been in contempt of the court. That's per the understanding of the Attorney General. And I'm saying that, what happens to the president if he's in contempt of court?
Yes, and I'm saying that even the advice of the Attorney General himself, he didn't tell the president not to receive it.
I get that. He says don't assent to it.
Yes, he said don't assent is different from don't receive.
Right. So I'm saying that what could possibly be the legal ramifications?
If he had received and assented.
If he had received and assented, what would have happened to the president?
Yes, if he had received and assent, of course, then it more or less interferes with the due administration of justice.
And then what will happen to the president?
And of course, contempt consequences can flow.
No, I disagree.
As a certain president?
No, please, let me
because
land.
I'm told you can't sue the president.
Honorable, let me land.
Okay, please.
Contempt will land, but not personally against the president.
Personally against the president?
Not in his personal
capacity.
But of course, the Attorney General will have been sued.
Oh, I get it.
Well, Attorney General by virtue of Article 88 is answerable to the acts of the President, not the executive,
Oh,
which the
okay.
President forms part of
I
the
get
executive.
it. I get it.
So
I get
it is the
No,
Attorney
please,
General,
please,
but the
I don't want
President is
anybody to
personal
interfere when you are
capacity
talking,
cannot
I
be
beg you.
sued.
Yes.
But it's even his action that could have been questioned.
Okay.
But in practical terms,
Yes.
to what end would it have
Okay.
been?
All
To
right.
hold the Attorney General himself and cast him in prison custody?
I get it. I get it. All right. I'll come back to you, John. I beg you.
Can I answer
No,
this?
I beg you. I'll beg you. John,
No, ask whether the president.
No, I beg you. I'll come back to you on that. I beg you. Dr. John Osai Kwapo is also on. Doc, Doc, let me. Doc, are you there?
Yes, I'm here.
Yes, thank you. Thank you very much. Now, Doc, I mean, are you as worried as some of us? I mean, we know that yes, there's the principle or the theory of the separation of powers, the executive, legislature, and then of course there's the executive, and then there's the judiciary. Now, we know that these three arms of government have their own, they enjoy their own kind of autonomy, or are autonomous in their spheres of endeavor, or say, influence or province. But then they are also supposed to, relate to one another, not necessarily overrule one another. But we're beginning to see a situation where Parliament and the executive are flexing muscles. How did we get here, and why should we be worried, or should we be worried?
Thank you. I mean, the impasse and this conflict does raise, a few concerns or some questions for me. So, as Lawyer John said, the issue of contention here is what happens between passage and when a president gives his or her assent to a bill or otherwise. And as he clearly stated, the Constitution, describes what happens, right? So there's nothing that says the president cannot receive, a piece of legislation passed by Parliament whilst, he or she decides, what do I do with it? Even upon the advice of the Attorney General that, look, there's an issue in the Supreme Court, therefore wait for it to be resolved. That is why, for me, I thought the presidency could have avoided escalating this by issuing that letter to Parliament instructing them not to transmit the bill. As I described it during this week, I felt that was a bit of an executive overreach. But having said that, I also see, in my opinion, it appears to me that the president is in some kind of a dilemma. That's my reading of it, which is there are two dimensions that he has to reconcile. One is the external factors, should he decide to give his assent to this piece of legislation, right? Yes, Ghana is a sovereign country, but we are also a part of an international community, and we have very good relationships and allies that I'm sure we are sensitive to some of their concerns and comments over this piece of legislation, which they have made very clear. If you look at a lot of the international headlines after the bill was passed, you would see some of those angst or some of those concerns being expressed. So that's the one half of the dilemma. What are the consequences? Maybe there may be no consequences, maybe there will be, but we don't know yet what those consequences will be. Then there's also the internal dilemma, which for me is more political in nature. So if you look at, the politics of the legislation is not on the side of the president should he decide to withhold assent on this piece of legislation. And I say that because if you look at the most recent Afrobarometer survey, and that question has been asked 3-4 times, there's a question about, you can think of it as discrimination or tolerance, where a number of individuals, there's a question about, would you approve or disapprove if, these types of persons were your neighbor? So people of a different religion, of a different political party, and then, people who describe themselves as homosexual. And you have as many as 9 out of 10 Ghanaians who say they would strongly disapprove if their neighbor, were homosexual, right? Which by extension says to me that such a bill then would definitely have the support of the general public. So how then do you sort of go against this sort of general public wind that is blowing in favor of a piece of legislation like this? So then if you withhold assent, I can see that your main political opposition could weaponize this against you. And yes, he's not on the ballot, but his party is on the ballot and his party's candidate is on the ballot. So there are all of those dynamics that come to, in my opinion, create this kind of, dilemma. And how do you reconcile this dilemma? But beyond that, for me, there are two important issues here. One is the role of the judiciary in our law and policy making process. Are we now setting a precedent where between passage and whether a president gives his or her assent to a bill, right, that there's now another step that we are going to go through, not as a matter of law, but as a matter of, procedure where, Parliament passes something, a citizen disagrees, an institution disagrees, boom, we run to court. And therefore, now that we are in court, even transmission cannot be done. And moreover, then is it now that, a president would only give his or her assent after a Supreme Court has weighed in on, whether what Parliament has done is okay, or not. And then how do we pick and choose when we apply this new, I don't know if we want to call it a precedent, a principle, all of that. And so for me, that is one of the concerns and what would be the consequences of that? Does it necessarily now begin to drag the policy making process, the law making process, or is it something that we believe, it's a good practice to have now? I don't know, but it's something that I've given some thought to, and it gives me a little bit of, concern. The other point that gives me concern is what sort of future relationship between the executive and the legislative branch of government does this precedent, create? Yes, if the president's party had the kind of majority it had when they first came into office, I don't think this would be, I don't think this would be an issue, right? But when the configuration of parliament is different, it changes the dynamics of the relationship between the executive and the legislature. And at that point, it calls for, greater cooperation. It calls for mutual respect. I mean, the burden of having to work with a different kind of parliament is not the same when the parliament is, I would say, quote unquote, more friendly and more controlled by your own party. So having said that, what happens now between the way, the executive relates to the legislature? Because whilst they are independent and co-equal, they still have to work together, to address, important issues, important public problems, right? That is why, again, if you look at something that the speaker said towards the end of, his statement, I share those sentiments because for me, you would have to give a certain level of recognition and respect to your co-equal branch of government in how you deal with them, especially when the configuration in the 8th Parliament is not the same as we have seen, in other kinds of parliament. I personally, and I've said this over and over again, I'm not a big fan of politics that is unnecessarily adversarial in nature, right? I like politics that is more conciliatory, in nature. That is why this impasse and what it means for even this administration and the last, 9, 10 months it has in office, its relationship with Parliament, bothers me.
But how about those who also say that it is also a political truism that where the organs of state are actually doing the proper checks and balances, we get to benefit?
I mean, yes, in any democracy, and as a matter of good governance, yes, you do want proper checks and balances, right? So whether it's the whether it's Parliament, exercising its proper oversight role of the executive, or whether it's the judiciary coming in as an umpire to call into, let's say, the president takes an action and, it's an affront to the Constitution. You would need some independent body to be able to rule on that action, right? So that's why, for example, you have the courts. If Parliament were to exceed its power or to do something that creates injuries, etc., you need some process, to resolve that. So yes, there's a proper rule for for the courts, for ensuring accountability, for ensuring oversight, all of those things, and it is part of democracy, and it is part of good governance. But again, for me, and that's also by my very nature, it is when it starts getting overly adversarial, right? That is where, for me, it starts to give me some discomfort, because now here you are, based on the president or the presidency's action and the letter that was sent to Parliament instructed them not to transmit the letter. Now you have a response from Parliament as the speaker saying, all well and good, but here's what we can also do. Your nominees under consideration. We are not going to consider them until this other matter is also resolved, if that's the principle that we are going by. The president needs his appointees, I'm sure, to get to work and manage and implement and do all of the things for which he has nominated them. So if it takes the Supreme Court 1 month, 2 months, the rest of the year to decide both issues, hopefully not. Are we then at an impasse where the president doesn't get his executive appointees, whilst at the same time then this bill passed by majority, by Parliament, also then ends up languishing somewhere. So you see how all of these dynamics doesn't portend well for for good governance, and how we practice our democracy.
Right, John, there are two things I'd ask you. We have to take a break, but there are two key questions that I'd like to ask you when I come back after I've gone around the table, where my resource persons will give about 5 minutes submission each, because we want to make sure that everybody gets an equal chance to comment on the matter, because we don't have all day. But here's the thing. Now, the speaker says that this is, so first of all, he gives a context when he was actually delivering that statement in reaction to what the president's executive secretary had written to Parliament. It says, to situate this statement, which was about to deliver in the appropriate context, it is crucial to acknowledge a disturbing pattern emerging from the executive branch, which points to a concerning disregard for the foundational principles enshrined in the Constitution. It says this pattern has once again been made evident in the president's recent refusal to accept the transmission of Human Sexual Values Bill. The recent move is not isolated. It forms part of a series of actions that undermine the legislative process. As you may recall, I addressed this House on 22nd December 2023 in a formal statement. The purpose of that statement was to draw your attention to the president's refusal to assent to the 3 critical bills that had been duly passed via as a private member's bill. During that address, I underscored the troubling nature of the president's justification for his actions, or rather the lack of thereof, particularly highlighting that his failure to assent to the grounds of alleged unconstitutionality paradoxically stood in violation of the very Constitution he invoked. And it says, despite the gravity of the matter, it is disheartening to note that there has been no progress in rectifying the situation concerning those significant pieces of legislation. They remain in a state of limbo, unacted upon, following the President's communication, which lacks substantial legal justification. So there's a certain sense that the President is not cooperating or collaborating with Parliament the way he ought to. And that, for the Speaker, is very troubling. And it says, and I read the first statement, it said, it is undermining the principle of constitutional democracy. I'd ask your thoughts on that, and then I'd ask about the way forward and what you think should happen, because there's some who have said, President just put a call to the Speaker of Parliament. He's a friend. You've been in Parliament with him for almost 4 terms. Talk to him. Come to a certain understanding so that we all benefit. Because when 2 elephants fight, it is those on the ground who suffer. So those are the 2 key questions that I'll be asking you. I'll take a short break. When I come back, this is Inside Pages on Metro Television. All right, welcome back. This is Inside Pages on Metro Television. We've got 2 lawyers here. One is a politician, one is not. And there's a lawmaker here, the member of parliament for the Tamale Central constituency. And I have a man who's a political scientist, is an advocate of democracy and democratic governance. And I'm talking about Dr. John Osai-Kwap, and we're having a very interesting conversation about what has been trending this whole week, which has to do with the president's posture when a bill which was supposed to go to him for him to sign, he says he can't even accept the bill because his lawyer tells him that if he accepts it, there'll be some, legal consequences. And that has been challenged. In fact, the honorable member of parliament says, no, he's not a lawyer, but his commonsensical reading of the law says nothing would have happened to the president. They've just gone ahead and signed like he did with the e-levy. And so, all of this excuses are just meant to buy time. The man now doesn't want to sign anything. That's what the honorable member of parliament is saying. But Lawyer Marco Abuedu, I know you have to leave us. And so your fellow colleague has made certain submissions, or has some submissions, and you're saying that you have a take on it before you take the office.
Yes, unfortunately I have to leave.
John Midebugri.
Yes.
John.
Essentially, I am saying that let us not make a generalized comment that once the Constitution has said he shall, then he's exercising a constitutional mandate, and therefore nothing stops him.
Yes.
Because the Supreme Court interprets the Constitution.
True.
All right?
True.
So once that is before the Supreme Court, then he has to cease whatever he's doing. Otherwise, he undermines the authority of the Supreme Court.
Okay.
The Supreme Court has a sole mandate to interpret the Constitution. No other court has that. Sorry, yeah, which is before the
Law
Supreme
is
Court.
Supreme Court for interpretation.
Wait. So if you are going to say that because the same Constitution gives it a mandate and therefore you should act, even though the matter is before the Supreme Court, I think that's a bit of a stretch. And then let's not even also begin to entertain thoughts that the president cannot be cited,
Yes.
Because the Article 2 is clear that if an enactment, it didn't say if the Constitution, an enactment, and all enactments will flow through the Constitution, though.
Okay.
Then it's specific. The president shall, if he gives directives, the president shall.
Right.
And then if the president does not, it is grounds for
impeachment.
Impeachment, exactly. So you see, of the 3 arms of government, the ones that we visibly see are those who are executing. That's why the executive, they're executing.
Right.
Of the ones that the next line that we see are my brother's house, Parliamentary, because all the laws that the executive will use to execute is emanating from them.
Right.
The ones which are quiet are the judiciary. Those are the ones with the power.
Right.
Because they can, but then someone has to come to them before they exercise that power. But if a matter is before them, we have to be careful how we do things.
Right.
You see, this contempt case,
Yes.
Odo Nimapao, all right, became popular because Odo Nimapao was the president of the National House of Chiefs.
Okay.
He was cited for contempt.
Right.
No, still. So, because even when you are treating our traditional authorities, they are very careful. But there comes a time when they will flex their muzzle because certain lines have to be drawn.
Right.
So we should be mindful of that.
Right.
And then let's not just say that because the president did something first, you should repeat that. No, let's just respect the authority of the court.
Right.
And I am saying that let's depoliticize this whole matter
But here's the thing.
and let it go through the steps it has to go through.
But here's the thing.
This
This
act has
Just briefly.
Wait. This act has certain aspects that I think if we calm our heads down, we want to look at it.
Okay.
Certain aspects.
Right.
I'm sure if it goes to finally gets to the president and all these matters are out of court,
But I have-
he may come back.
Yes.
My personal issue is
Yes.
that the custodial matter. All right. Are we separating those convicted from where they will spend the time?
Not at all.
So are we asking?
They're going to cohabit to everybody. They're going to live with everybody.
With
With the street, yes. Hoping that the street would straighten.
What do I think? Because it
Well,
is
we hope
said.
not. We hope not.
Yeah, it is said that when you are going in, you are straight. When you
Yes.
come out, you may.
You're crooked.
Exactly. So we should calm down
Yes.
and look at ways where we are restoring people because we don't hate them. We
Yes.
hate their act. So let's calm down. Let's see how we restore.
I don't think we hate
Okay.
armed robbers too.
Exactly.
We hate their act.
Yes, but we are
But
saying
when they
that.
do, we
but we're saying
deal
that
with
there's the
them.
danger. I am saying that there's a danger where if you're going to mix them with the same people in the prison where they don't have women,
Yes.
the temptation is
Yeah, but now
higher
you're getting into
than
some
what-
aspects of the bill. Now,
Precisely.
remember, it's before the court.
Precisely.
And you're saying that once it's subjudicated, we shouldn't comment on it.
No, I'm not
Because-
commenting on the success of
Yes.
it. I'm talking about the bill itself. I think
No,
when
no,
we
no,
come
because
out,
no,
we
Richard-
are all against this.
No,
act.
Richard
When we come ahead-
Richard Sky's suit
Yes.
or writ
Yes.
actually calls for a declaration of that aspect that you are talking
Oh,
about.
right.
Exactly. It's part
Right.
of the things, some of the
Exactly.
reliefs that he's seeking from the
Exactly.
court. That's what I'm
So
saying.
when we come out,
let's be careful we don't get into that
also
aspect.
said that he's not for that practice.
Well, he said he
Exactly.
said he's
so
straight.
let's when we
do,
calm our
do
heads
people
down.
believe him?
Yes.
Sorry.
It's one thing people believe in what he says.
Oh, he's. I know he's.
No,
I know
he's not here.
I know
He's
he's.
not-
I know
he's
he's
not
married
here.
with about
I'm
4 or
not
5
saying
kids.
anything
so,
derogatory. I'm
yes.
saying that when he said he doesn't believe in it,
Yes.
there are people who are contesting that position. He's
No
my
problem.
friend.
That's
I
fine.
know he's straight.
And then,
That's fine.
and then
You
my
know, but I'm
last,
saying
and
that-
then my last one before I leave is, please, Mr. Speaker.
One of us said he knows him as a friend,
Please.
and he knows he's straight.
You know,
No, but let me ask you
please,
something.
Mr.
Let me ask you. Let me ask you
Mr.
something.
Speaker,
No, there's something I need
please.
to ask you. There's something I need to ask you. I beg you, just 2 minutes.
All right.
Why have you shifted position? When the president went ahead to
As in-
sign, no, I'm talking about you as in the New Patriotic Party.
Okay.
When the president went ahead to sign the e-levy,
Yes.
despite the interlocutory injunction which was in court,
Yes.
you defended him and said, look, the president had to go ahead and sign.
You see, there are two issues.
He called a bluff of those.
No. There are two
You
issues
said to
here.
hell with the interlocutory injunction.
No.
So help me
No,
appreciate
no.
it. That's what I'm asking.
There are two issues here.
Okay.
You see, the first one is notice.
Okay.
Okay. Now, the bill was passed.
Yes.
The next day,
Yes.
and a writ was issued.
Okay.
The next day he signed it.
Oh, what's the difference?
All right.
Come
So there was
again.
one day between when it was passed
Yes.
and when he signed it. That day before then, the writ was
No,
issued.
he's talking about you defending.
No, hold
the
on.
course, that action.
Wait, I'm
So
trying
this is
to
about
explain.
timelines.
Yes. I cannot confirm whether when the writ was issued,
Whether he was aware.
whether he was served or whatever.
Okay.
That's one.
Yeah.
But then
He
two,
was.
when he
Yes.
is pushing a bill through
Yes.
for economic reasons,
Yes.
it's different from when
He's against a bill for economic reasons.
Oh, so you're saying that e-levy emanates from the executive.
exactly.
But
And they
the
were trying to
proper
stop
sexual human
us-
rights and family values
They were trying to
is a
stop
private
yes,
member's bill.
Exactly. They're trying to stop us from going to IMF. Remember?
Yes.
They said that this will solve. Will plug that hole.
Yes, it's a
All
homegrown solution.
Now this one
Yes.
has financial consequences.
Yes. It has a charge on the key to
I
public
told you.
safety.
Exactly.
Yes.
So you see, we have to.
Moro, I told you,
we
it
cannot-
has
they are not
nothing
on
to
all
do with law.
fours. They are not. Is
It
that
has
right?
nothing to do with law. It has
Right.
to do with money.
Oh, no. That's the point he's making. He says one is a
It's a
private
legal
member's
argument
bill,
I'm making.
And this one has to
one
do
is from the
financial-
executive.
It's a legal argument
But his
I'm
point is
making.
that once it's executive,
No,
nothing is
he
emanating
concluded
from
by
him, so
saying
he'll
that
go ahead and sign.
it has
That's
financial
what I'm saying.
implication.
I am saying that.
Okay.
You see, I'm saying that.
Yes.
There's the issue of notice. We don't know whether he had notice.
Yes.
When he signed it. We don't
Yes.
know.
Okay.
Okay.
Yes.
Now, we're also saying
But
that.
it was a public. It was a subject of public conversation. It was all over the place. When the minority said we were going to go to court, it was all over the
I'm
place.
saying that I do not know.
Oh, you're saying the president didn't know?
I am saying I do not know whether the president
was aware.
had notice of that.
So you'll be surprised and disappointed that the president knew and yet went ahead to sign the
That's
bill.
not what I'm saying. If I don't put words in my mouth, bro, this morning, don't put words in my mouth. On a very
No, I'm
good
just
note-
saying.
on a very good
No,
note-
flowing from that logic. I'm
on a
just
very
flowing
good
from that.
note,
No, flowing from that
I'm
logic.
about to leave here.
Okay, all right. Thank you so very much. Lawyer Awa Kwamwedu is a private legal practitioner, also a member of the New Patriotic Party's communications team. I want to thank you very much for joining us. So, Honorable, so I'll come back to you before I go to Dr. John Osai Kwapo. Now, there was some concerns that you wanted to raise. You're talking about separations of powers and why you think that should be the cardinal issue that must basically guide the conversation we're having.
Well, my earlier
And why you
comments
disagree
were
that
just
this is
preliminary,
interrogatory, yes.
and I made the point forcefully that
Right.
all the discussions and the argument back and forth that we have has nothing necessarily to do with law. It has to do with money. It has to do with the IMF. I mean, if many people still remember, the president had a program and he said that he understands that there was a case in court
Yes.
by a Ghanaian.
Yes.
At the time the president was speaking,
Yes.
the writ hadn't been filed.
True.
So it means that he knew
Yes.
that Richard Sky was going to court.
Yes.
How did he know?
Oh, but but that's just security.
Oh, please, it's not
He has
national-
intelligence.
Please, it's not
There's
national
DNI.
security. I mean, we know.
He gets daily briefing.
Please. I know the proximity between Richard Sky and the majority leader. They are very good friends. I know. I mean, they are my friends. The president told us, so it means that he lied. Either he knew, someone informed him, or he knew the action Richard Sky was going to take.
Yeah, but it won't be strange for the president to get to know.
Why?
Oh, he's very
Why?
well connected
So couldn't he have waited?
for the action to be
Yeah,
filed.
he said that he
Before-
knew that someone was in court.
Yes.
He didn't say he knew someone was going to
go to
court.
court, okay.
He said he knew someone was in court.
Right. At the time he had him in
At the
file.
time when it wasn't filed.
Okay.
And until a case is filed in court,
Yes.
it is deemed not to be before any court.
Okay.
It was the next day that Richard Sky, the writ was actually filed. So
Yes.
that's one point.
Okay.
Two, that argument that the president could not have accepted or assented to reform, I absolutely disagree. The president could have accepted and assented and he wouldn't be violating any law, and I don't think that he would be contemptuous of any court. The president has the moral duty and the responsibility to fulfill a constitutional obligation as stated in Article 1067. A constitutional duty. So between fulfilling a constitutional duty or obligation and the case in court, what bearing does it have on it? What I do know is that the Supreme Court's mandate is to interpret laws. As we sit today, there isn't any law before the Supreme Court, if you ask me. Because this bill becomes a law when the assent is given by the president. Then it becomes a law. But as we sit now, it has not even been transmitted. The assent or otherwise has not been given. So what are we dealing with? In fact, as someone who is not a lawyer, I'm wondering what case will be determined by the Supreme Court, because if you ask me, I don't think that there is any case before the Supreme Court, because to interpret, the Supreme Court interprets laws.
Okay.
So if you ask me, so the other thing is that,
Yes.
now, when we talk of separation of powers, the whole concept of democratic governance is anchored on separation of powers.
Right.
Where the three arms are expected to have equal powers and work in collaboration with each other for the betterment of the citizenry. And that powers must not be given to one arm or another arm against the others. That there must be a sort of detente, that they have equal powers in terms of what they each can do at any point in time in a complementary fashion for the purposes of achieving the whole idea of good governance and democratic growth.
Okay.
Now, if that is the argument, now we should not be arguing that is seeking to give authority and power to one arm against the other. Now, once we do that, then it defeats the purpose of separation of powers. Now, if the argument is made that any action that is taken by the president would be at variance to the court and by extension undermining the court, it therefore means that any action the court should also take should not undermine the executive arm. Unfortunately, this president has yielded the authority of executive arm of government and by extension, the other arm, which is the legislative arm, at the altar of the judiciary. That is what they have done.
Okay.
Such that even your constitutional duty, if you want to perform, you must have the green light from the judiciary before you can execute or perform that function.
Right.
That for me is dangerous as far as our democratic growth is
Let me
concerned.
go to John, and before I come to Dr. John Asako. John, there's another issue. Now, just yesterday, or I think 2 days ago, we saw the Attorney General's advice to the Speaker. And first of all, I'd like to ask you whether the Attorney General has a capacity or has a locus, let me put it that way, to even advise the Speaker of Parliament, because that in itself has become a contentious issue. I just heard Lawyer Kingsley Wambakubo said that the Attorney General is the legal advisor to the government of Ghana, not just the President. And so he has the capacity to do that, advise the legislature, the judiciary, and so on and so forth. So that's one. And then the second issue is that he says he did a search at the registry, and he's found out that apparently it's only a writ. And I'm going to read a portion of what he said. He says that, so please find attached the results of a search conducted at the registry at the Supreme Court. Whilst it is true that a relief was a search, so he said he did a search 2 days ago. That must have been on Wednesday or so. So this one is on the. Okay, no, I don't have the results of the search here, but this is the statement he issued to the Speaker of Parliament. It says, whilst it is true that a relief stated on the writ filed on 18th March 2024 referred to above purports to be an order of interlocutory injunction restraining the Speaker of Parliament from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President of Parliament, it goes without saying that the same is not an application for interlocutory injunction. Every application for interlocutory relief in any of the Supreme Courts, as it is tried, must be by a motion. You see, by a motion specifically filed and praying for the desired relief. The mere statement on a writ of summons of a prayer for interlocutory relief is inconsequential and of no effect. It does not constitute a pending motion for such a relief, and no one is required to take notice of same. 4. In any event, it is pertinent to indicate that the substance of Mr. Dafiamako's suit is a challenge on the power of the President to relieve ministers serving in his government of their portfolios and reassign them to different ministries. It has no bearing on the approval of persons newly nominated by the President as ministers and deputy ministers and duly presented to the Parliament for approval in accordance with Article 78(1) and 79(1) of the Constitution. And it says, in light of the foregoing, Parliament, in my respective view, has no inhibition or any barrier in proceeding with approval processes for the ministerial and deputy ministerial nominees. What do you make of what he has said? I mean, based on his search.
We want to respond to the question of whether or not
He has locus.
he has the capacity.
Or capacity, okay.
Yes.
To advise
yes.
the Parliament.
Yes, as my learned friend who just left said,
Yes.
the Attorney General is the principal legal advisor to the government. But government here knows the three arms of government and its institutions.
Okay, before you go ahead, I'm told that I've not even advertised the WhatsApp line. That's so unfortunate. That I'm so sorry about that. It's 0249 155 646. 0249 155 646. So join us via WhatsApp or text 0249 155 646. Thank you very much. And my sincere apologies for that. Yeah, please go ahead.
Yes, so advice in the real sense of the word, yes. The Attorney General can advise Parliament because Parliament is a legislative arm of government.
Okay.
Yes. But I thought that since the Attorney General is principally going to be counsel for the defendants in this instant case,
okay,
all these observations he had made of could have been advised in private.
I see.
Because essentially, he is the one going to defend.
Okay.
So if you are going to defend me and then you come and watch...
You're going to defend the Speaker?
Yes, he's going to defend.
The Speaker?
Because the Attorney General is going to defend.
Right.
Yes. So if you're going to advise me and you come out to share my weaknesses, the weaknesses in my case to the public, then what have you done to me?
You've only cut your nose to spite your face.
Yes.
Right.
So I thought that these pieces of advice,
was uncalled
which he
for.
said, to me, fell too short of his duties as an Attorney General.
Okay.
Yes. Number two, on the issue of the search, as at 10:35 or thereabout, there was a motion for interlocutory injunction properly so filed.
And that was before the speaker? The speaker delivered his statement? Or that was after the speaker delivered his statement?
That one I can't tell.
Because that is what-
But
so that is what is in
as at
contention.
10 thereabout, there was a motion properly so called.
Wednesday.
Eh,
When was it? Because you see, the timing is key in this. Because the Attorney General is saying that as of the time the speaker was delivering that statement, he must have been ill-informed because there was only a writ of summons.
But when the president said he knew that someone was in court, was it Attorney General who advised
by
him
any case, the
that
point-
someone was in court when there wasn't any writ before?
The point I'm making is
get
this.
that.
So what is the
I'm talking
Attorney General
what the-
talking about?
Yes, but I get that.
No,
Please
the
go
point
ahead.
I'm making is this. Even
Yes.
granted that,
Yes.
at the time he conducted the search, that was 11 something.
Yes.
But after that time,
Yes.
after 10, the motion was filed. So how come that he didn't get the results?
No, but if the motion had been filed,
As at 10.
so I need to ask you something. If the motion had been filed prior to the speaker's statement, what would have been the effect? If the motion had not been filed prior or before the speaker's statement,
Moro, can I ask you a question?
But
The day in fact, I just want to ask a question so that the day the president said
yes,
that he could not take any action on the matter because
Yes,
someone
yes.
was in court,
yes,
there wasn't any writ before any court.
yes.
The president stated,
I get
I'm
that.
coming,
I
I'm
get that,
coming,
Honorable.
I'm coming,
I
I'm
get
coming,
that.
I'm coming.
But
can
that
Moro,
we-
Moro,
we-
can
that
I
you
finish?
had an
I'm
issue
coming,
with.
Moro, let me
No,
finish.
you had an issue with that.
No, I'm saying I want to finish on this. The president's statement,
Yes,
this was a president speaking.
yes.
So who informed him that there was a case before any court?
We've asked that question already.
So
We don't have an answer
granted
yet.
that there wasn't any motion filed before
Yes.
any court.
Yes.
And let's assume that the speaker erred.
Yes.
Let's assume
Right.
the president erred too.
Okay, that's fine. So by priority of
in fact,
reasoning,
I'm not holding brief for
For
the
the
speaker.
speaker. Okay.
But I am assuming.
timing is key in all of this.
Yes, I'm assuming
Okay.
that the speaker was very categorical.
Yes.
That he had been served
Okay.
with a writ. A writ.
Okay.
No, so I'm
Yes.
assuming that
Yes.
the president was,
Yeah, he was served,
the
yeah.
speaker was under the presumption that clearly maybe the interlocutory injunction was also part of the processes that,
Okay.
that were set on him.
Okay.
I'm not holding brief, but that's what I'm beginning to
Assume.
assume.
And I
Yes.
ask you that so you see, there's a politics and a law. Legally speaking, if there wasn't any motion on the day the speaker was delivering it, if there wasn't any motion of interlocutory injunction which had been filed at the court, big if,
Yes.
will the speaker legally have been right to say that an injunction has been filed, and so I'm unable to proceed?
Yes, in that case, the speaker respectfully
Erred.
will have erred.
No, Moro,
But-
Moro.
but-
The
No, I'm saying
speaker-
an if.
No, I want to
Honorable.
provide an answer as a member of parliament. The speaker,
I wanted to land.
No, it will help your point.
It's
The
suspicious.
speaker, parliament is the master of its own.
Yes.
Even without any case in court.
The speaker can decide.
The speaker
not to.
can decide that we are not going to consider this matter.
Really?
Yes, the speaker can do that.
Oh, how?
Oh yes, the speaker can do it. But I'm
Can
saying
decide
that, I'm
I
saying
won't vet your nominees.
No, he said we won't consider the matter
Okay.
because we think that there is a case. In fact, it's not even necessarily court. If a public opinion, there's
Yes.
so much concerns about, the speaker can decide on the basis of this.
But would that be?
I don't think it is prudent. Which law is
Really?
he going to
Would that be a
evaluate?
substantial grounds?
Why? When there is a huge public opinion or
Against something.
against it, that's a substantial ground.
Okay. Okay. Please go ahead. Yeah.
yes.
So you're saying you would assume that once there was a rate, the speaker would also say, well, it came
I
with
think maybe that was his assumption,
assumption. Okay.
and I'm not holding brief for
That's
him.
fine.
That's
That's
what I
That's fine.
think.
That's fine.
Yes. So I'm thinking that the issue of the Attorney General going ahead to try to discuss the competence or otherwise of the rate
The rate, yes.
that Honorable Nelson Dafiama, of course,
Yeah, rate, yes.
to me was very unfortunate and inappropriate.
Right. Why?
Because I don't know whether he uses a different rules book of the Supreme Court.
Okay.
Well, I think I have one here.
All right. Rules of court.
Yes,
CI 16.
yes,
Okay.
and Rule 45
It's clear.
of CIC, and then Rule 46. It's very clear on the point. It's written in a plain language, in ordinary man.
What does it
reading
say?
will understand.
Okay.
The Rule 45, the jurisdiction of the Supreme Court is invoked by a writ,
Okay.
accompanied by a statement of case.
Right.
That's right. But the rule further says that if you issue just the writ without the state of case, you are given 14 days within which to do that. And if you fail to do that within 14 days, the defendant has the option to apply to the court to have your writ struck out.
Okay.
So the fact that the writ had been issued
And there was no statement
and there
of
was no
case.
state of case, as he said, did not even invalidate the
The writ.
writ.
Okay, the
as
validity
at
of
that
the-
time.
the validity of the
Yes.
writ.
And even if it did invalidate the writ, it was up to him to move the court to have it struck out.
Okay, that's fine. Let me go to Dr. John Osai-Kwapon. Doc, so I'll wrap this whole up with you. And I asked about just two quick questions. We have just 5 minutes to do this. So the speaker is not happy that consistently bills that go to the president, bills that are birthed by a private member, has found all kinds of reasons and grounds to basically reject it. And he's saying that this undermines good corporate governance. And then secondly, what do you think should be the way forward? Because as things stand, nobody has reached out to anybody for them to come to some kind of consensus.
So on the first question, the response of the president to some of these private member bills or the concerns that has been raised by the speaker. If in the three instances that you mentioned, if the president, in his own opinion and upon, let's say, advice from the AG that he had strong constitutional reservations or strong concerns about the nature of the legislation, and so therefore he expressed it and decided to withhold his assent. I don't see that necessarily as trying to undermine, the work of Parliament,
Yeah, but you see,
unless
Doc,
it becomes.
Doc, just a quick one. But you see,
Yeah.
you see, there's got to be context. Now, let's also be mindful of the fact that the role of the executive in the legislation process, it's simply, it's perfunctory, to say the least, or it is administrative. So Parliament can actually go ahead and get its own bill passed into law, whether or not the executive agrees or not. So will it be in the interest of the executive to keep coming back to Parliament with all kinds of reasons why something cannot work? That's where I'm coming from.
Right, you're correct. But if you also look at our legislative practices, how many private member bills have we seen, in the Fourth Republic? Do you see what I'm saying? So you're correct. Parliament is the lawmaking body, but at the same time, the executive also has some role to play in that lawmaking body. And my overall point, though, is that I'm not sure that at this point I would want to stretch that argument to a deliberate, intentional attempt by the executive, as embodied in the presidency, to undermine, to undermine Parliament, right? The Eighth Parliament and its relationship with the executive has, been different, if I should use that word, compared to, other parliaments that we've seen. But then having said all of that, yes, I would say that there's been some executive overreach, particularly on this legislation, especially on that instruction to Parliament not to transmit the legislation. I think the executive could have stopped short of doing that. But having said all of that, for me, the way forward, I think you had mentioned that you had heard something about, the president reaching out to, the speaker, to have a tete-a-tete with him, right? No. For me, that is the kind of sort of informal ways of resolving.
Doc, what I said was there are some who have asked the president to put a call through to the speaker.
Yeah, and for me, right, sometimes some of these things you also need backdoor diplomacy, right, to resolve them, and so it's not a bad call, right? It wouldn't hurt anything to have this sort of diplomatic resolution to figure out a way forward that says, okay, we will consider your nominee. But then again, what would be the speaker's demands as well, right? Okay, we will consider your nominees, but allow us to transmit the bill or take a position on the bill. some way, somehow, for me, talking through this and finding some points of reconciliation to resolve this impasse would be my preferred, approach. I don't want each of the arms to keep digging in their heels and escalate this impasse. I cringe at the prospect of that.
Okay. All right. Thank you very much, Dr. John Osai-Kwapong, for your time. It's been wonderful talking to you, sir. So I'll give the rest of the, I guess we have 2 minutes more. I'll just give a minute to each to my resource persons to wrap it up, because otherwise they'll take us off. A minute each. Yeah, so in conclusion.
In conclusion, I would want to state that the whole impasse here is just, looking at the law and then looking at the end results.
Okay.
It's just the unwillingness, unfortunately, on the part of the president to assent to the bill. The reason is that if you read Article 106, I think from clauses 9 to clause 12, the implications are that if the president refuses to assent to the bill and indicates to Parliament that there's a specific place in the law that I want it considered and amended, or I prefer it to Council of State, and they also bring their recommendation, and Parliament is bound to reconsider them and then submit them again to the President, and the President is bound within 30 days to assent it. So to avoid this constitutional provision, the President said, I want you to receive it so that the timeline will apply to me. So for me, the end of the conduct of the bill is an attempt in a subtle way to overreach the Constitution and avoid performing its constitutional duties. And that's the whole essence of this.
Right.
And it is gapped in the lawsuit.
Right.
Which, by the time, more or less, who knows, that the matter is determined, then he's out of office. I know that I didn't sign or I refused to sign.
Right.
So to me, if you read the Constitution at Article 106, 9, clause 9, 10, all the way to 12. That's what it says. If the president refuses and then it is reconsidered by Parliament and it is resubmitted to him, he is bound within 30 days. So the whole thing of a lawsuit, I'm aware of this, is just to buy time. So the president at that time would have left office and say, okay, the court didn't finish the matter, so that's why I didn't sign. Yes, that's what I see it.
I get it.
Yes.
And like I said, we have just 1 minute. If we go beyond 1 minute, that the MCR will take us off, Honorable. So, but do you foresee a situation where the Dafiamakw's case will be heard speedily so that the vetting of and approval of nominees can go on? Whilst that of Richard Sky will take a bit of time?
I hope so. I think that my friend in his statement admitted that it has to do with financing. It has, in fact, the legal argument is just used as a decoy. Everybody knows.
I'm talking about your work as parliamentarians. And do you foresee a situation where the Dafiamakw's case will be heard quickly? Because
I hope so.
So that the vetting and approval of the ministers can go on.
Yeah, I hope so. I'm told that the Supreme Court, I think.
But would you be surprised? Because Richard Sky's when Dafiamakw's so Dafiamakw's case went before Richard Sky, or the other way around?
Richard Sky's case went there before
so ordinarily you would expect Richard Sky's case.
Yeah, the issues of this guy's case, I'm told, is going to be heard.
Which one?
If I'm not mistaken, yes. I read.
But why not
something
Richard
like
Sky's?
I don't know. I think that $1 million question should be asked. But the point but no, on a more serious note, we know the position of the president on this LGBTQ thing. We know the position of President Mahama. All those who are aspiring to lead, the Dr. Ayarga has stated his position. We are still begging for the position of Dr. Baumia. And I am particularly worried. I am particularly worried because I'm a Muslim, he is a Muslim. He needs to tell us his position. He needs, and he shouldn't have any position except that which will be against the LGBTQ. No, it can't be his position. He says that he has his own vision. So we want to know. In fact, if he comes out with any position, I don't think that will be meritorious enough. It should be as a result of a pressure. And there shouldn't be any pressure on him for him to tell us what his position is on the LGBT.
Thank you very much, sir. Thank you very much, the Honourable Member of Parliament for Tamale Central. I also want to thank John Ndebugui, private legal practitioner. Dr. John Osai-Kwapong is a member of the CDD Ghana, a fellow of the CDD Ghana, and also a political scientist. My name is Aldoboro. Thank you very much. Let me also say a big thanks to Kingsley Mwakubuedo, who is a private legal practitioner, member of the MPP's communications. Have a great weekend. Bye-bye.